by 282 members to impeach the Deputy President. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the Deputy President would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged, then commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my Lords, parties were then invited to respond to every allegation. This was a two-tier trial, my Lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my Lord, Articles 94 and 95, donating powers to Senate and to the National Assembly, respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my Lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either access their powers directly or through their elected representatives. So my Lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My Lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question, that the petitioner participated in the entire trial. Only the petitioner, my lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented his case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body, each senator, considering the allegations and bundles served to every senator prior to the trial. My lords, it was on the 17th, and this is an important distinction, at 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness but did not reach him. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My lords, there's a curious point here, and this is important, my lords. The provisions of Article 145, 5, and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented, 145.5, the President or Deputy President shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. My lord, then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my lords? That was accorded, my Lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my Lord, he was present during the entire presentation of the case by the National Assembly. But third, my Lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My Lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this, my Lord. At 5 p.m., my Lords, the Deputy President, the Counsel for the Deputy President, Senior Counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Care Nostro. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my Lord, Counsel and his team, Senior Counsel Paul Mwite, Eminent Counsel Elisha Ongoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my Lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my Lords, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my Lord, every opportunity was presented to the respondents to present, but they opted, my Lord, not to proceed and not to provide any document to Senate at that point to, my Lord, confirm, my Lord, at the point that their client or the Deputy President, in that matter, was unwell and admitted. Senate then proceeded, my Lords, to vote on that question. My Lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my Lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My Lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my Lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my Lord, that the proceedings were to conclude was the Saturday, the next day. My Lord, unfortunately, Senior Counsel Mwite, and the Hansard will demonstrate this, my Lord, had applied for an adjournment to the following Tuesday. My Lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disappearing. My Lords and your leadership, the petitioner had taken part in the cross-examination of all the parties. No case, my Lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the Deputy President. My Lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend, Mr. Masharia, made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my Lord. My Lord, that was a substantiation of a charge on economic crimes that failed. Only, my Lords, 5 out of the 11 charges proffered against the Deputy President petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my Lord. That out of the 6 charges, my Lord, the Deputy President was convicted on the gross violation of Articles 10(2)(a)(b), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is live before this court, my Lord, that is on violating his code that requires him to undertake certain function and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my Lord, in the grant of conservatory orders, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority in this area, clearly. My Lord, on the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think on the scales, weighed highest, that this court must take into account the import of a conservatory order issued ex parte against public interest. My Lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the Deputy President, my lords and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a Deputy President sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect Munya. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kithure Kindiki, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic of Kenya. My Lord, wherein would his remedies lie? Malayan Friendly Body would submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week's salary that is 6 that I should have been or to have been Deputy President, that would be compensated in monetary terms. But this country, my Lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My Lord, if I move to the other point, my Lord, we have submitted that since every opportunity was accorded to the Deputy President to present his case, and that he failed to present his case, my Lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my Lord, because the authority in my movie Sonko and Nairobi City County Assembly, and again I argued this one, my Lord. In part, I was in this matter. In this case, my Lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to fault the process leading to his impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stating that one, there was the Hansard that contained reasons. Two, my Lord, in terms of an impeachment, my Lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my Lord, that that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Counsel on the other side submitted that there was need for a committee. Senate, in its proceedings, my Lord, in its wisdom, had voted to proceed through the whole House and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My Lord, we submit, my Lord, that unless the processes of Senate are faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gacgagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My Lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki, a very good man. Thank you, my lords.
Thank you.
My Lord and my Lady, my name is Modomidi Nkolu for the second interested party, and to that end, we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have, in addition to that, filed a list and battle of authorities on that preliminary objection, and that list and battle is dated the 25th day of October 2024, and pursuant to your directions, those are the battles, my Lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have in addition filed written submissions, skeletonal submissions dated the 27th day of October 2024. Before I delve into the PO, my Lord, a suggestion was made to you I had forgotten to tell you, my Lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my Lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my Lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me why we have raised this PO and you find that I deserve to be laughed at, it's okay. My Lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution, to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my Lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My Lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this: that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My Lord, it is clear by dint of Article 58, sub-Article 5, that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My learned friend, Mr. Ngwe, talks of the word decency. I hope we are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear if you have a dispute as to that matter. Never mind it has abrogated the entire Bill of Rights. The court you go to is not the High Court. It is the Supreme Court. My Lord, property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my Lord, I'm here very humbly to tell you, the mere fact that someone has run to you screaming Article 23, Article 165, does not without more mean that this court has jurisdiction to hear that matter. In other words, my Lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my Lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gidu Muigei's issue about justiciability, then you have no jurisdiction. Luckily, my Lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my Lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bado, my Lord, the Bado of Authorities. We have produced you, or rather before you, extracts of the Boma's constitutional, the Boma's draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one, A, Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debates through the Boma's process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course, we know, my lords, the Boma's draft was one of many. The next draft that was generated in that process is at page 7 of our Bado, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub-Article 4, that the Supreme Court has, paragraph A, exclusive at the line exclusive. We moved from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was the WACO draft. We have produced it at page 10 of our Bado. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you'll find there, Article 184, Kenyans were still toying with the idea that the courts can interfere with this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is the draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And since that rule was always on the table, my lord, but was dropped from the final draft, we must take it that the final decision the people of Kenya made at the referendum of 2010 was that there would be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144. Yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced Article 144 on page 13 of our Bado. My lords and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules, it tells you, 144, Article 144.8 of our Constitution, is that the report of the tribunal shall be final and not subject to appeal. And if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall also communicate. And of course, it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is, the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144.9. And when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal on removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the million-dollar question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction, and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about the Bill of Rights, but the High Court has no jurisdiction. That's what we mean when we say in our PO, my Lord, that there is Supreme Court jurisprudence in this country. I'm addressing you now on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojeda was involved. But my Lord, we are told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Ojeda is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention them. My Lord, let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993. I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my Lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years, now and counting. Why this decision is important, my Lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have to quote my good friend Ongoya, the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you check the rule now in issue, Rule 11 here, Rule 11 in this decision of the Senate. So this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding on you. But more important, it is also about impeachment. What happened in this decision, my Lord, is quite interesting. The person who had been impeached was a judge of a federal court in the US. He was sent to prison, but refused to resign from his judicial office. And because in the US, judges hold office for life to the extent that he refused to resign, it meant the US Treasury was bound to continue paying his salary and emoluments while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives and the Senate, took up impeachment and impeached this judge. But when you follow the holdings in this case, my Lord, they say at page 20 of Wabadu that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Sonko case and the Wabora case, that is exactly what our Supreme Court has said, following this decision that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the US the Supreme Court of the Republic of Kenya. And my Lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General, Emeritus Professor Muigai, if you go to page 21, my Lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my Lord, this specter of the country being held on tenterhooks as this matter is fought here, is fought in the Court of Appeal. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our Bado. And the reason I'm referring it to you, my Lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable. But there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white, there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rehnquist tells us here that nobody should have to make heavy weather of the idea that this type of dispute is not justiciable. Lastly, you are told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authority is on page 51 of our Bado. I don't have time to take you through it. We have produced the Sonko decisions. We have the citations, the quotes we've lifted in our written submissions. And all we are telling you, my Lord, when all is said and done, is to do either of two things. Hold, you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative. If we must infer jurisdiction, because that's what you're being asked, let's infer it at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there is a question for me.
Thank you.
My Lord, my lady, if it may please you, my name is Milimo. My Lord, I'm here to address you on 3 grounds. Specifically, my Lord, one on public participation, The second issue, my lord, I'll be addressing you on is fair hearing, with reference, my lord, to the National Assembly. And lastly, on the nominee, my lord, the deputy presidential nominee. My lord, on the first point of public participation, you shall note first, my lord, that there is no one in the petition before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my lord, is that it's common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my lord, dictated by Article 118B of the Constitution. And, my lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my lord, to refer to the Supreme Court BAT decision. And specifically, my lord, at page 45 of that decision, which we have attached, my lord, to the first respondent's supplementary list and bundle of authorities dated 28th of this month. My lord, the second authority that I will refer you to on matters public participation is the recent authority, my lord, that was rendered last week by the High Court in the affordable housing decision, my lord, that is petition number A154 of 2024, and specifically, my lord, at pages 178 to 179, rather to 184 of that decision. My lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my lord, has been undertaken in the history of this country. And, my lord, I will refer you to the annexed public participation report, and specifically, my lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And, my lord, very quickly, you note that over 224,000 people my lord, over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My lord, I'm trying to establish the fact that heavy weather was made, my lord, on the fact that there was no public
We have
participation.
noted those heavy weathers, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the issue before the courts. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my lord, I stand guided. And then that...
In other words, Mr. Milimo, you may spare us the submission on the sufficiency of the public participation.
Correct, my lord. Yes, my lord, I stand guided. And I was just going, my lord, to refer you to one authority that we had, my lord, attached as authority number 1 in the supplementary list of authorities. If you are to look at page 4 of that authority, my lord, the sufficiency or otherwise of public participation exercise, my lord, is to be determined at the main trial. And, my lord, therefore, I would agree with you that all I need to do, my Lord, is to refer you to the report that I've indicated, my Lord, that it appears at page 427, specifically the findings, my Lord, to 455 of the replying affidavit. But, my Lord, allow me just to pick one thing out of that report. You are particularly, my Lord, referred to one of the constituencies, specifically, my Lord, Keio South constituency, where my learned colleagues, my Lord, raised issues that indeed the figures did not tally. My Lord, first, you shall note that the figures that were quoted by the petitioners, my Lord, are contained nowhere in the public participation report that have been submitted before you. My Lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My Lord, Keio South views, my Lord, are submitted to be found firstly at page 289 of the report, my Lord, and it appears as item number 95. And this goes specifically, my Lord, to the hand-delivered and email views, where it was indicated that, my Lord, there was a total of 465 responses, and out of those, my Lord, 455 were in support. That is what, my Lord, is contained in the report as the first limb. The second limb, my Lord, is for those who participated in the public hearings of the 4th, my Lord, of October, and is found at page 331. Same Keio South constituency. And, my Lord, it's indicated that a total of 355 people did, my Lord, attend that public hearing. And out of those, 352 persons, my Lord, supported the motion. Lastly, on that point, my Lord, is to refer you to page 440 of the replying affidavit, my Lord, where you shall note, not 440, my Lord, I'm sorry, page 439, where, my Lord, you shall note that the total responses in respect of Keio South constituency were 820. And that out of those, my Lord, in support were 807. So, my Lord, the views are submitted, or the submissions are submitted by my Lord and colleagues, my Lord, do not find any favor in the report. And therefore, my Lord, I'll urge you that you do ignore them. My Lord, I also need to point out that public participation, my Lord, is not a referendum. As well understood, my Lord. And that in the words, my Lord, of your learned brother, justices and sisters, my Lord, in the affordable housing decision, public participation does not, my Lord, necessarily mean that everyone in the country must give their opinions. My Lord, that is paragraph 175 of the affordable housing decision. And that, my Lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my Lord, to submit their views. And, my Lord, you shall note that in the report, all that was done by the National Assembly. And therefore, in the fullness of time, my Lord, we shall demonstrate before you that there's absolutely no arguable point, and the public participation exercise that was conducted, my Lord, by the National Assembly was not only meaningful, but was sufficient both qualitatively and quantitatively. My Lord, the other issue that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my Lord, that elections are conducted at the polling stations. My Lord, that submission is not true. The presidential, my Lord, elections are provided for in terms of being conducted, my Lord, at Article 138(2), where it states, my Lord, that the elections are at the constituency level and not at the polling station. My Lord, the other issue that arose from the submissions from my Iranian colleagues is whether, my Lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My Lord, my answer to that is simple. That first, my Lord, the public participation exercise commenced on 2nd of October all the way to 5th. And my Lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my Lord, that response could have been availed to the public. Secondly, that, my Lord, the National Assembly only avails what is in its possession. And therefore, at that point, my Lord, the National Assembly could not have been accused of not, my Lord, presenting to the public what had not presented to it. But more important, my Lord, there is no legal requirement, and none was cited by our learned colleague, that dictates that the National Assembly had a duty to present, my Lord, that response to the public during public participation. And last, my Lord, nothing stopped the first petitioner, my Lord, from himself presenting that response to the public, as he did, my Lord, on the eve of the hearing or proceedings at the National Assembly. The last point, my Lord, on public participation was whether, my Lord, the Senate ought to have conducted the public participation exercise. And, my Lord, my answer to that is this, that under Article 118B, my Lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my Lord, Parliament under Article 93(1) refers to both the Senate and the National Assembly. And, my Lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my Lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my Lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my Lord, then it means that even this court sitting in exercise of a judicial function, it could be required, my Lord, to undertake the public participation exercise.
Mr. Melema, we only entertained you on these submissions because we had entertained other people earlier. That is the only reason we are listening to you.
I thank you, my Lord. But I'm winding up on that, my Lord. Yes. My Lord, the second issue that, my Lord, I'll invite your attention to is on the subject, my Lord, of fair hearing. My Lord, and on that limb, there was a challenge, my Lord, to the standing orders of the National Assembly. My Lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my Lord, and that at this stage, being an intellectual stage, this court, my Lord, has no power to invalidate those standing orders, my Lord. In the fullness of time during, my Lord, the main hearing, we shall demonstrate to you that those standing orders, my Lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my Lord, is to implement those articles of the Constitution. The other issue, my Lord, that was raised was about impartiality of the Speaker of the National Assembly, my Lord. Yes, and my Lord, you shall note that the Speaker of the National Assembly, my Lord, has no vote in the proceedings, and that is, my Lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my Lord, is not a valid submission. And, my Lord, more importantly, my Lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And, my Lord, he did file a substantive response to the notice of motion. And more importantly, my Lord, he was given 2 hours to present oral representations. That opportunity he took, my Lord. And therefore, the question of there having, my Lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My Lord, my last point is on the nomination, my Lord, of my good teacher, Professor Kindiki. And my lord, the issue was whether there ought to have been, my lord, an approval process at the National Assembly, and whether, my lord, there ought to have been public participation, as well as, my lord, the timelines that were invoked, my lord, to process the good professor. Yes, my lord, all I need, my lord, to bring to your attention is there was a ruling, my lord, by the Speaker of the National Assembly that we attached to the first respondent supplemental list and band of authorities, dated, my lord, the 28th of October this year. And, my lord, you shall note that in that communication, the Speaker did address all those issues, my lord. The communication, my lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, my lord, to refer to it when you retire. My colleague, Mr. Macharia, my lord, on a light note, told the court that, my lord, I would have said Weta Tosha. My lord, I'll say that in 2032 when the right comes. I thank you, my lord, unless your lordship have any questions.
Thank you.
My lords and my lady, I'll proceed from where my learned friend Mr. Milima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Joroge on the 21st of October 2024. My lords, we also have submissions in response to the application seeking conservatory orders dated the 27th of October 2024. And finally, the list and digest of authorities dated 27th of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. In understanding the application and the prayers that are currently live before the court, permit me to draw your attention to the application filed by our learned colleagues in the matter 565 for 2024 for just one purpose only. The application has a total of about 13 prayers. The prayer number 1 all the way to prayer number 10 have been spent. In other words, they've been overtaken by events. The last prayer, which perhaps would have been relevant for purpose of understanding what I'm trying to get to, is prayer number 9, which talks about that pending the hearing and determination of a petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of a person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William Samoei Ruto, to fill the vacancy of the office of the Deputy President of the Republic of Kenya. That prayer is equally overtaken by events. The last prayer is for deletion of what they call falsehoods to various persons and institutions. It then follows, my lords and my lady, that the petitioner, His Excellency Rigathi Gacgagua, has no prayer that is live before you in relation to the question of conservatory order. Looking at the application number E015, the only prayer that is live before you is prayer number C and prayer number E, both of which deal with the question of swearing in of the second interested party appointed by the President and approved by the National Assembly, they say, from assuming the office of the Deputy President. It then is our submission that the threshold question, the arguability question, the nugatory question needs to then address the issue of swearing in. I will then straight go to the issue of swearing in. My lords and my lady, we've spoken to the provisions of Article 145.7. 145.7 very clearly indicates that if at least 2/3 of the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. May I add to the submissions that have been made previously that that provision is a self-executing provision. You do not need more. It is not an action of the Senate, it is an action of the Constitution itself. The first question that then we would want to ask ourselves this afternoon is, in light of view of such an express provision of the Constitution, is it tenable that an order of this court would issue to stop it? Let me take as one step further to remind us that at the point at which the Deputy President was impeached, he then acquired a constitutional blemish. And we say a constitutional blemish because under the provisions of Article 150, all the charges that were substantiated as against him, including the question of gross violation of the provisions of this Constitution, serious reasons to believe that the Deputy President committed a crime under the national or international law, and gross misconduct, then were issues that would be said to have informed his constitutional standing. Now, where am I going with that? I'm trying to make the point that when the Constitution, therefore, has put a dot or a blemish on you, then certainly you become unsuitable to hold office by dint of Chapter 6 of our Constitution. That is, specifically, I would draw your attentions to the provisions of Article 73, Subarticle 1, which says, talks about leadership and integrity, responsibility of leadership. It says, authority assigned to a state officer is a public trust to be exercised in a manner that, 3, brings honor to the nation and dignity of the office. To the extent that those grounds were established under Article 150, it simply means that the person of His Excellency the Deputy President therefore lost the capacity. And why that is important is then, as you consider this question as to whether to grant the conservatory orders or not, would he be one person who would possibly be considered for that situation? And our answer is a simple no. Permit me to speak to the issue of now Article 149. Article 149 reads, within 14 days after vacancy in the office of a Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. First point I would want to make, just to complement what my learned friend Mr. Muthomi has spoken to, as to the justiciability. If the Constitution says that within 14 days of coming into play of Article 145(7), is it practical, is it tenable that within those 14 days, if a party were to have come to court, then going through the hierarchy of the High Court, the Court of Appeal, and the Supreme Court, any dispute touching on that question of nomination would have been resolved? That then speaks to the architecture of our Constitution, to the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Sabbatical 2, speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, we then relate this to the events of first Article 94, Sabbatical 2, which says the role of Parliament shall be Parliament manifests the diversity of the nation, represents the will of a people, and exercises their sovereignty. What point am I trying to make? A lot of heavy weather has been made about the candidate who has been presented for purposes of approval under this Constitution. Now, one of the issues that has been raised is that there was no public participation in relation to the candidature of Professor Kithure Kindiki. My lords and my lady, allow me to just take us very quickly to the provisions of Article 149 to provide some bit of context. That within 14 days, allow me to just read it again, within 14 days after a vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days. Vote is the word used. I want to persuade you, my lords and my lady, that the action that the members of the National Assembly would be taking pursuant to this 149.9 flows from the delegated authority under Article 1, Sabbatical 2. It also flows to the role of parliamentarians under Article 94, Sabbatical 2, to exercise the will of the people of Kenya, to exercise their sovereignty. In other words, that is a choice that the National Assembly is making as the representatives of their people. And why that is important is the very question that follows, is when making that decision, is public participation an imperative? Our answer, my lords and my lady, is a straight no. And so that then I give you context. Let me give us what happens in the ordinary elections, and which will be at Article 148. Article 148, Sabbatical 1, reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at Sabbatical 2 that for purposes of Clause 1, there shall be no separate nomination process for the deputy president, and Article 137 1D shall not apply to the candidate of a deputy president. What then do we read from that? It means that a simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that that is what happens, we don't then subject them to public views around what people think about them, sending a memorandum. Once that nomination is done, there is no more that follows other than the declaration after the election itself. Now, why is this important? It is important